Imagine these common circumstances. You're your father's only child. You're 40 years old and you're a single mom. You're raising two minor children. Your father sets up a trust for his benefit during his lifetime and at his death for your benefit during your lifetime. Your father is the sole trustee of the trust during his lifetime. Your father, at the recommendation of his estate planning lawyer, names a fiduciary licensed by the California Professional Fiduciaries Bureau as his successor trustee. The fiduciary has been licensed for several years and focuses on conservatorships. The fiduciary's website says that he also administers trust. Your father meets with the fiduciary once before executing the trust instrument. Your father's expressed intent in the trust instrument identifies his primary purpose to support you during your life. Any undistributed trust assets at your death are left to St. Jude Children's Research Hospital. Your father expresses his intent that the trust is established for your health, education, maintenance, and support. This is often called the HEMS standard. That is, the trustee shall distribute sufficient funds to you for your health, education, maintenance, and support. You learn that this standard is specifically referenced in Internal Revenue Code Section 2041B1A. Your father dies. You meet with the estate planning lawyer and the fiduciary a few weeks after your father's funeral. You learn that under the terms of the trust, the fiduciary is now the successor trustee. The trustee estimates that there's $4 million in the trust. The fiduciary indicates that he is gathering trust assets. He wants to know if you have any of your father's property. He tells you to move out of your father's house. He makes no inquiry whatsoever as to your health, insurance requirements, living expenses, school expenses, or general standard of living. The trustee acts like and says he has unlimited discretion in making any principal or income distributions to you. He's apparently more interested in having an estate sale and selling your father's house. At the present time, he indicates that he is inclined to give you nothing. He wants to preserve capital. And now you wonder, does he have unlimited discretion? Did my father make the trust to benefit a licensed fiduciary whom he met once in his lifetime? Wasn't the trust made for my support? And you have some common sense observation. Isn't the trustee required to diligently and in good faith investigate your need for support before declining to make a distribution? Aren't the trustee's actions extraordinarily imprudent, unreasonable, and substantially out of step with the settlers, that is your father's, intent? Are the trustee's actions in good faith? Are they in accordance with terms and purposes of the trust? In the interest of the beneficiary? Isn't the trustee under some kind of duty to act? While the trustee has an ascertainable discretion to make distributions for your support, does such an ascertainable discretion include the discretion to pay nothing, to contribute nothing for your support? So the referenced circumstances are just one example as to how beneficiary litigation against trustees can come about. Circumstances, of course, differ in every case. If you want to speak with Hackard Law about your circumstances, then call us at 916-313-3030. We focus on significant estate, trust, probate, and elder financial abuse litigation in California's largest urban superior courts, including Orange, Los Angeles, Santa Clara, San Mateo, Alameda, Contra Costa, and Sacramento counties. Thank you for listening.